Good morning. Today we are with Alexandra Bondikov. She is our immigration attorney here at Pollack, Isaac, and DeCicco. Today I have a question for her, and thankfully she will answer, hopefully. So the question is, can you please tell me a little bit about H-2B visa and the process?
I'll try. The H-2B visa program was implemented to address shortages of workers in particular fields. It is not for everybody. It's meant to fill in a short-term, seasonal, temporary, or peak load need. And when we think about what seasonal means, it's in the name. You can only perform certain tasks within the season. A great example would be landscaping services, and they typically run from April to December. Temporary need, the job itself, the duties itself may exist throughout the year, but for whatever reason, there is a high demand in particular times of the year. For example, if you run a resort on Cape Cod, it's open year round, but people take vacations in the summer, so you need more staff. Peak load is when you have a one-time occurrence that is not predictable. For example, you are a construction business and you only handle a couple of projects at any given time, but for whatever reason, you score this one big contract and it's a multi-unit dwelling and you need the workers, but you don't have them. That would be an appropriate use for the H-2B program. People ask me whether any national from any country would qualify. No, the Department of State has come up with a list of countries that are eligible for the H-2B program. Mexico is one of them, because this seems to be where most workers come from as a practical matter. It's a fairly involved process. It consists of 3 distinct stages, and depending on whether the foreign worker is in the United States or abroad, it can involve 3 separate government agencies. It starts with the Department of Labor. It's a process we call temporary labor certification. Basically, during this time, the employer has to prove that they do have a temporary need and that there's nobody here in the United States able or qualified to do the job. This typically involves conducting some form of recruitment, which is provided by the Department of Labor, and it's very rigid and strict. It involves placing advertisements in the local newspaper and a job order with the local Department of Labor. It also requires the employers to obtain what we call a prevailing wage. It basically is a determination by the Department of Labor that the workers would be paid a particular wage. Once we've done all this, we file a labor application with the Department of Labor, and sometimes the Department of Labor requires evidence of the temporary need, in which case the employer would have to provide some sort of proof that the job that they have is indeed temporary, seasonal, peak load in nature, and that means contracts or payroll records to show that during the past year they employed more workers during a particular period. Once the Department of Labor certifies the labor application, the second step would be filing the actual visa, non-immigrant visa petition with the United States Citizenship and Immigration Services. At that stage, if it's approved, the workers can then either apply for visas at the consulate abroad, which would be the Department of State, or if they happen to be here in an H-2B status from another employer, they can extend their stay while they're here. They do not have to leave the country. The H-2B visa worker program has been in the news recently, and that is because there's only a certain number of visas each year. There's only 66,000 each fiscal year. The fiscal year runs from October 1st till September 30th of the next year. And to make it more equitable, Congress divided the quota into separate halves to address the seasonal need of workers who need more workers in the summer versus the winter. Traditionally, the second year cap, the one that's the need starts in April, has been in demand. For the past 3 years, there were many, many more applications than there were visas available, which prompted Congress to allow for more numbers, which in turn turned out to be also inadequate. So if a company is considering petitioning for workers, they need to realize that if their temporary need covers the second half of the fiscal year, meaning April to the end of the season, there may be a lottery, which is just that, a lottery. USCIS would randomly select petitions that were filed within a 5-day period starting April 1st. April 1st is the first possible day to file an H-2B application with USCIS. The other big deadline is January 1st, when petitioners are supposed to start the first stage, which is the Department of Labor filing. So basically, it's an involved process. It requires several steps to be taken prior to the filing. So our advice is, if you are considering filing for workers, you need to start well in advance of your date of need. As an example, if the start date would be April 1st, you really need to have started in October. The workers have to, of course, possess the required qualifications for the job. If the employer requires certain skills to perform certain tasks, then the people who will be coming in to perform those duties need to be qualified or experienced. The actual time that an H-2B worker can spend in the United States would depend on the period of need, and if one worker has already been counted towards the quota, then if they change their status or extend their status through another employer, they do not have to go through the quota system again for the fiscal year. If you're considering filing for H-2B visas, or if you have any further questions, please contact our firm. We'll be happy to help and answer any more questions that you may have.
Thank you so much, Alexandra.